Welcome, everyone. We're going to talk today about abortion, but we're going to talk about it in reference to a Supreme Court case that you've probably all heard of, and which is the centerpiece of the legal status of abortion in the United States. So we're making a small departure from our normal kinds of articles today. Normally we focus on ethics, and I've told you before, and it's very important, so I'll repeat it. Ethics has some relationship to religion, and ethics has some relationship to law, but the three things are not identical. Okay? So law and morality, which is what's important for today, are not identical. Now, they're not opposites, right? There are a lot of options other than things being exactly the same and identical and things being opposites. They're just different, Baseball and swimming are different sports. They're not opposite sports, but they're clearly not the same exact thing. So we want to make sure that we don't confuse the legal status of abortion with its moral or ethical content. So we're going to talk about the legal status of abortion today, because when most people think about abortion as a moral, ethical issue, they immediately think of the law of the land. And I think in this case that makes a lot of sense. That makes perfect sense. The point is that we're going to talk about the law as law and just say what the law of the land is. Then we're going to pivot and ask some ethical, moral questions, basically saying, does the law square with what ethics and morality say about abortion? So we're going to do sort of a two-step today in a way we don't exactly always. We're not going to try to support or challenge the article on its own grounds. Because if we were going to challenge or support it on its own grounds, the way it reasons, we'd have to be legal scholars and constitutional scholars. So what I'm doing is I'm going to explain how Roe versus Wade works, because everyone knows this court case and almost no one understands how it actually works. So you, after this, will be one of the few rare Americans who actually know how the constitutional federal law regarding abortions works in America. So trust me, once we go through this recording and you've done the reading already as well, you'll know a lot more about abortion's legality in the U.S. than most Americans. So I just think that's important because it's a touchstone. You just say Roe versus Wade and almost every American knows what you mean. And yet I didn't know all this stuff about it until I read the actual court case. So that's going to be sort of like a factual lesson. We'll talk a little bit about how American constitutional law works, which is a bit of our sort of social political side of this class. Then we're going to pivot and we're going to ask certain questions then we'll interrogate the law in terms of moral and ethical questions. Okay. So, I just told you, and I'm being honest, that I didn't understand how Roe versus Wade worked until I read the case, Roe versus Wade. That is, I didn't understand how abortion law worked in the U.S. I guess I sort of knew that you could get an abortion and then you couldn't at a certain point, which is not false. Also, something I didn't know until I'd been teaching these sorts of things for a while is I didn't really quite understand how constitutional law works. That is, I did not understand what it means for something to go to the Supreme Court. Now, some of you know that. Some of you just finished your civics class in high school and went over this in great detail. Some of you are political science majors, and this is like your bread and butter. This is like 101 for you. But for a lot of us, these are things that we didn't get in high school, or I think the case in my high school is that they taught it to me, and don't tell my teachers, but I think I was not paying attention in civics class, because this was new to me at about age 25, I'd say, is when I figured this out. So if you're in the same boat as I was, which is not uncommon, we're going to do a little civics lessons today, a little bit about how state law and national law interact. Okay, So, first things first, Roe versus Wade is the name of a Supreme Court case. Roe is one side of the legal dispute, basically, and Wade is the other side of the legal dispute. That's what the verses mean. Okay. What happens when things reach the Supreme Court is that there's some sort of dispute about a law, and that dispute takes place in lower courts, like state courts, county courts, and then if it's challenged, again, basically if it's appealed, like when a criminal appeals their sentence, it can sometimes move up to higher and higher courts that have more and more authority. And if it keeps doing that, it works itself all the way up to the Supreme Court. So here's something about the Supreme Court. And this is like Civics 101, but it wasn't clear to me until I had it explained to me later on, is that courts, including the Supreme Court, never make laws. Courts in America never make laws. Legislators, the Congress, okay, the House of Representatives and the Senate together are Congress. They make laws. Okay? And sometimes the executive branch sort of makes laws. They give directives or orders, but let's ignore that for a second. So, courts in general, and the Supreme Court specifically, never make laws. So, the Blackmun court did not make abortion law. What the Supreme Court does is it interprets existing laws that states have made. It interprets those laws and asks if they fit with the Constitution. Okay? So, the Supreme Court never makes a law itself. What it does is it takes a law that somebody else made, Congress usually, and then says, hey, is that law really count as an American law? If it contradicts the Constitution, the highest law of the land, if the individual law contradicts the Constitution, it's not a real law. It's just words on paper, and the Supreme Court will void or invalidate or strike down that law. And you know, this is a little bit how philosophy works too, is all your claims have to be coherent with each other. They cannot contradict each other. But what the Supreme Court does is it just says, if anything contradicts the Constitution as the highest federal law of the land, we kick that law out and we retain the Constitution. Okay? So basically, if something goes to the Supreme Court, the same basic question is always being asked. Supreme Court, is this law that a state usually has passed, Texas in this case, does it fit with the Constitution or does it contradict the Constitution? If it fits with the Constitution, the Supreme Court says the law is valid, it's good, it remains a law with legally binding force. If, however, the law contradicts the Constitution, you nullify, you eliminate the parts of the law that clash or contradict with the Constitution. You strike them down is the normal language. So the same basic question applies to Roe versus Wade. Is this particular law a fit with the Constitution and therefore legitimate and valid, a real law? Or does it contradict and clash with the Constitution and therefore it would be an illegitimate or invalid law, not a real law? It's struck down. The answer in the case of Roe versus Wade is that the central components of the law in Texas were unconstitutional, so they are struck down. And then basically what we do today is we figure out what the general rules are that make an abortion law either constitutional or unconstitutional. Okay? So once more, Supreme Court never makes laws. It just checks existing laws against the Constitution. If they fit, they remain laws. If they clash, the Constitution remains law, and the other state law is struck down. So, what this means is that these laws are evaluated generally in terms of the Constitution, but more specifically, they're always evaluated in terms of rights that individuals have. Think of the Bill of Rights. And or evaluated in terms of powers or interests that the state has, both the nation at large and the individual state such as Texas or Rhode Island. Okay, so I'll say that again because it's important for this case. Yes, we say, is it constitutional? And that's what we mean. But that's really general, right? So what we mean specifically when we ask if something's constitutional, we ask if it fits with the individual rights, your individual right to free speech, your individual right to assemble in groups with other people, etc. Right? So we ask if it fits with the individual rights outlined in the Constitution. And we also ask if it fits with the interests of the state and the nation at large. And we mean the legal interest, not just like what would be nice. So what does interest mean? A state or national interest here? You can sort of think of it like a right that the state has. Things that the state is legally allowed to pursue and prevent. You don't exactly want to say states' rights, though, for two reasons. One is that technically a right is something that belongs to an individual. That's just what, right? They're human rights. States aren't human. They don't technically have rights. Okay, so individuals are the only bearers of rights typically. Second, the phrase states' rights is it's a term that, it's a very controversial term. It has to do with civil rights and whatnot. You and I can talk more about that if you're curious. But if you say the phrase states' rights, other people are going to hear a bunch of things that maybe you didn't mean. So in order to help you understand, an interest is sort of like the equivalent of a right for the state or nation. But please don't call it a right. It's confusing if you do so. Call it an interest of the state. Okay? So, why would a law ever go to the Supreme Court in the first place? Or why would a law ever be challenged in general? Basically, just think about what happens in courtrooms in general. In courtrooms in general, it's when there's two opposed parties. Now, in criminal trials, it's just a jerk who broke the law and an innocent victim. But when things go to the Supreme Court, they're usually not criminals against victim. They're usually two individuals who both have rights. And then some sort of situation has happened where it's not clear how we can give both parties full access to their rights. So I'll say that again. The Supreme Court is there often to adjudicate, that is, judge, right? When different rights come into clash, when they clash and conflict. And the goal of the Supreme Court is to find a way in which everyone's rights can be satisfied. And if they can't satisfy everyone's rights, you try to find some way to strike a balance where you get the sort of the best way to satisfy the most rights possible. If there weren't a clash of legitimate rights and interests, there'd be no reason for the Supreme Court to step in. It'd be obvious, right? So to put this in non-legal terms, we'll put it this way. Nobody likes abortion, right? Nobody likes abortion. But when there's an unwanted pregnancy, unintended pregnancy, etc., there's multiple things that people want that clash. There's multiple things people want, and it doesn't seem easy to satisfy all the things we want. In short, in a normal unwanted pregnancy, the kind of pregnancy where abortion might be an option, there's someone who doesn't want to have an abortion. Because trust me, no woman is like excited to get an abortion. So there's someone who does not want to have an abortion who also wants to have an abortion. So at the personal level, when someone's pregnant, there's always that clash if abortion's on the table. Wanting and not wanting to have the abortion at the same time. So roughly, a rough analogy is that in the court, you've got a woman who wanted to have an abortion, and you've got the state saying, we don't want you to have an abortion. Now, the state is, of course, allowed to tell citizens what they can and can't do in general. But, of course, individuals are allowed to do what they want to do in general. So we've got this basic legal clash. There's a woman who wants to do something, and there's the state who tells her she can't. States are in general allowed to tell you what you can and can't do, but people are in general allowed to do whatever they want. So how do we solve that clash? How do we leave individual women their right to do what they want, but also leave the state its interest in regulating what people do? And part of why the Supreme Court decision has been so contentious since 1973, when this was first written, when it became law, is that it's really hard to satisfy both the woman's right to do what she wants and people or the state's really strong desire to not see a bunch of fetuses get killed. So the goal is, as I believe Bill Clinton said this when he was president, but ignore who said it and focus on the content of it, is that many people in America think that abortion should be legal with an L, but very rare, right? Everyone in America wants to see the abortion rate drop. Nobody's literally pro-abortion, right? Nobody's excited about an abortion. But many people want to find a way that it's legal, at least in the case of incest, rape, etc. Right? And that's the tricky needle that the Supreme Court was trying to thread. It's a balance, as I said, between competing rights and interests, and it's a very difficult balance to strike. So, that's the sort of civics lesson. That's generally how the Supreme Court works. If anyone wants to add some detail to that in the discussion board, feel free. I'm just trying to give you a basic primer so we're all on the same page. But I know a lot of you know quite a bit about constitutional law from poli-sci, or maybe you've worked on legal campaigns, etc. So if you think there's something relevant that's been left out, feel free to add it in the discussion. But this recording will stop now. Then we'll pick up the recording that details exactly how the Supreme Court tried to balance the woman's right and the state interest. Okay, thank you, everyone.